Good afternoon, everybody. Welcome to the third webinar in our immigration detention series today. Thank you so much for joining. I'm Catherine Meredith. I'm a barrister here at Doughty Street Chambers and delighted to have Maya Sikand, Casey, and Mike Spencer, two civil actions and immigration detention specialists, to speak to us today. This is billed as an update, so it does assume some familiarity with civil claims in the context of immigration detention. Mike is going to speak first about the relationship between false imprisonment, other tortious claims, and HRA claims, Human Rights Act claims, and amongst a host of other interesting issues. And then Maya is going to deal with quantum, and I will finish with a little bit of a practical update. We're going to keep to the hour, so please do feel free to pop any questions in the Q&A because we'll leave some time at the end to hopefully deal with those. So without further ado, Mike, over to you. Thank you.
Thank you, Catherine. Good afternoon, everyone. As Catherine has indicated, mine is quite a broad subject to cover by way of update. I'm looking at false imprisonment, other torts, and claims under the Human Rights Act. What I propose to do is cover some of the basic principles in false imprisonment claims, which many of you will be familiar with, but it's just helpful to go back over those so that we know what we're talking about. And then a very brief recap on the issues that have been touched on in the previous webinars. And then I'm going to address 5 or 6 hot topic issues that have come up in recent case law. The aim being, hopefully, to better equip you as practitioners with identifying and addressing some of the problematic areas that might come up in your civil claims involving those in immigration detention. Next slide, please. So first, a bit of basics with which you'll all be familiar. The principal cause of action in any immigration detention claim is going to be a claim for false imprisonment in common law. That's a tort of strict liability, provided the claimant can prove that they've been imprisoned, and we'll come on to that shortly. It is for the defendant to prove that there has been, that the detention has been pursuant to lawful authority. Now, the Secretary of State has quite extensive powers to detain those subject to immigration control under the Immigration Acts for the purpose of deportation, and the courts have developed a series of principles regulating the lawful exercise of those powers. And those are generally referred to as the Hardiel-Singh principles from the case of Hardiel-Singh. And there are 4 main principles. The first is that the Secretary of State must intend to deport the person and can only use the power to detain for that purpose. The second is that the detention can only be for a period that is reasonable in all the circumstances. The third is that if even before expiry of that reasonable period, it becomes apparent that deportation cannot be effected within reasonable time, the power to detain lapses. And finally, the Secretary of State should act with reasonable diligence and expedition in effecting removal. Some overlap between those principles, but 2 and 3 are distinct principles, so that there may be circumstances where you have a reasonable period that hasn't expired, but during that period, it becomes apparent that deportation is no longer feasible within a reasonable period. The burden of proving lawful authority is on the defendant, and at common law is for the court to determine who has whether the defendant has lawfully exercised his power to detain, and therefore what constitutes a reasonable period, although that has been modified by for more recent claims by the Illegal Migration Act, which I'm about to come to shortly. Next slide, please. So sticking a bit with the basics, how do you work out what's a reasonable period of detention, assuming that there is a power to detain in the first place? There's some guidance in the case of I and subsequent cases based on that. So there's a non-exhaustive list. Each case is very fact-specific, and each case is highly fact-specific, and each case needs to be considered on its own merit. And it's not necessary for the court to identify a finite. It's not necessary for the claimant to identify a finite time within which removal can reasonably expected to be effected. So the factors include length of detention, whether there are any obstacles to deportation, the diligence, speed and effectiveness of steps taken by the Secretary of State in effecting removal, the conditions in which the detainees been kept, the effect of detention on them and their family, the risk of absconding, and the danger of offending if released. And the court is looking at the circumstances at the time as they could or should have or were known to the Secretary of State, so can't look with the benefit of hindsight, but is not limited to factors that were in fact taken into account by the decision maker. The courts have also established this notion of the grace period. So even where a reasonable period comes to an end, or it's clear that it's no longer going to be able to, the Secretary of State is no longer going to be able to effect removal within a reasonable period, there's still a grace period while the Secretary of State makes arrangements for release. And that was recently covered, or in 2020 covered in the case of AC Algeria, where the court noted a tendency of courts to extend that grace period and decried that and said that the period should only be a reasonable period to put in place appropriate conditions for release. So in the facts of that case, a 14-month delay in effecting release was not acceptable, and the court held that 2 weeks would have been an ample period on the facts of that case. Obviously, each case is fact-specific, and noted, importantly, for our purposes, that it's for the defendant who should be putting in evidence and making considered submissions as to what period is considered to be appropriate grace period and why. Next slide, please. Previous webinars in this series, if you haven't seen them, I would recommend that you get hold of the slides, and you can also get hold of the recordings by emailing events@doughtystreet.co.uk. And so I'm not going to cover everything that was covered in those webinars, but the first covered, of course, very importantly, the Legal Migration Act. And the IMA 2023 is important for two reasons. Firstly, of course, because the arrangements under the IMA for inadmissibility and removal to safe third countries such as Rwanda does affect and create powers of detention in that regard. But secondly, because there are also provisions of wider application, particularly Section 12, which codifies essentially Hardiel-Singh Principles 2 and 3, and says that it's for the Secretary of State and not the court to determine what is in a reasonable period, subject to Wensbury unreasonableness. And if you want to learn more about the issues around that, then do watch that seminar. And then the second seminar in the series was focusing particularly on vulnerable adults, changes in guidance and law around mental illness, mental capacity, and adults at risk, and the recent findings in the Brookhouse Inquiry Report. So also worth a watch. And again, not necessary for me to cover that in detail now. Next slide, please. So as I said, I'm going to focus on some of the hot topics that have been coming up in case law and to look out for. So firstly, what is an imprisonment? Secondly, the issue about subcontracting and finding the appropriate defendant. Thirdly, the relevance of public law errors in lawfulness of detention. Fourthly, looking at delays in finding bail accommodation. Fifthly, claims where detainees have been subject to unreasonable use of force, claims for damages around that, and then some further human rights damages issues, a sort of catch-all of some of the issues that have been coming up. Next slide, please. Issue 1, what is an imprisonment? It's quite an interesting issue technically for the purposes of damages claims. Jalloh is a very important case in this regard and worth always going back to, in which the Supreme Court held that a curfew requirement coupled with a tagging condition under license, where the person under license was required to stay within their residence between the hours of 11 p.m. and 7 a.m. did constitute an imprisonment at common law, and therefore, absent lawful authority, damages for false imprisonment would be available. And the court said that the essence of an imprisonment is being made to stay in a particular place by another person. And the methods by which you're made to stay in that place can be various. It doesn't have to be physical barriers, locks and bars, or physical people, such as guards, but can also be threats as to the use of force or even legal process. And there's considerable difference between voluntary compliance with an instruction and enforced compliance. And the fact that the claimant in that case ignored their curfew for some of the time was not relevant to the question of whether they had been imprisonment. And then looking at some of the cases around the lockdown, so in Francis, there was quite a grave argument that the COVID regulations, amongst many other challenges to those regulations, constituted essentially a house arrest, an imprisonment within the home, and the court held that they did not. The regulations prescribe where someone don't prescribe where someone must self-isolate, the only restriction being that they have to stay in a suitable place. And the court noted that you could leave the home for a reasonable excuse. So even at its most strict, the COVID lockdown did not constitute an imprisonment. And in NB, which was a case with Mr. Justice Linden looking at the treatment of not detainees, but residents who are asylum seekers who were housed in Napier barracks under asylum support legislation during the COVID pandemic, looking at those conditions, whether a curfew that had been imposed on them by Clear Springs, the accommodation provider, constituted an imprisonment. And Mr. Justice Linden held that it did not, because although there was an expectation, and although the claimants were informed that they would have to come back every evening to the barracks, and obviously there are aspects of the barracks that kind of looked like and felt like a prison, the actual evidence of the claimants was that there would be no consequence for them doing so, or the consequence would really only amount to being locked out for the night. And the claimants were aware of that. So in that case, it was not held to be an imprisonment. And just pausing on this slide, I acted in a series of claims with Laura Dubinsky around people confined into hotels during COVID lockdowns, and similar issues arose in those claims, looking at whether the treatment and the instructions that asylum seekers were provided with at that time constituted imprisonment. Next slide, please. Another typical issue which arises because of the extensive contracting out of Home Office functions is who your defendant should be in any claim. And that's been, and whether the appropriate defendant has been identified has been an issue that's come up in a few cases. So in GB and Home Office, a GP, a detainee was held by G4S in a detention centre run by G4S, and a private contracting GP had come in to prescribe anti-malarial drugs to that particular detainee, which triggered a psychosis. So the issue, clearly that detainee would have had a claim against the GP, but was unable for various reasons to bring that claim. So the issue arose as to whether the detainee could bring a claim against the Home Office. And the court held, applying the principle of non-delegable duty of care, that on the very specific facts of that case, the Home Office, as the detaining authority, had a non-delegable duty towards the detainee to ensure that any medical treatment provided was not negligent. And so the claimant was able to bring a claim directly against the Home Office in negligence. That's quite unusual on its facts, and obviously whether the non-delegable duty can be relied on will be very fact dependent on the circumstances. I mentioned Ali and Serco, which is a claim really involving asylum support accommodation, but in that case it's quite interesting as to what constitutes a public function. But for our purposes, the courts have been quite clear that private contractors who are operating immigration detention centres are exercising a public function for the purposes of the Human Rights Act. And therefore, Article 2 claims or Article 3 claims can be brought directly against those contractors. Those I've listed two damages claims there. They're both Article 2 claims. And Carr, Mrs. Justice Hill, looked in particular detail at the argument that Serco in that case, sorry, no, it's G4S in that case, did not have the Article 2 duty did not apply to them, and she refused to strike out the claim on that basis. So it's in these sort of Article 3 or Article 2 human rights claims, it may well be that your claim can lie under the Human Rights Act against both the Home Office and the contractor. Next slide, please. Another hot topic is the extent to which public law errors give rise to an unlawful imprisonment or false imprisonment. So the principle was stated in Lumber that a public law error can result in detention being unlawful where the error is material, sorry. And there have been some recent examples of the application of that principle. So in Kambadzi, there was a failure to review detention in line with policy, and that was very clearly linked to the lawful authority to detain, and therefore rendered the detention unlawful, not from the beginning, but at the point at which the review should have been carried out. Hamati was a case involving incompatibility with Dublin 3. Again, the detention there was unlawful. DN Rwanda was where the deportation order was made pursuant to an ultra-vires statutory instrument. And because the detention was based on the deportation order, that then rendered the detention unlawful. In MXK is quite an interesting case about an unpublished policy directing immigration officers to stop and detain individuals with NHS debts at the airport for the purpose of taking their contact details and passing them on to the NHS trust to whom they owe money. And the court held that that was unlawful for two reasons. Firstly, because it breaches Hardiel Singh Principle 1. It's not for the purpose of deportation, it's for an ulterior purpose. But secondly, because it was reliant on an unpublished policy, and it's a principle since Lumber that an unpublished policy can be unlawful. Next slide, please. One big problem, very common, comes up in immigration detention claims is where the Secretary of State, the detainee is granted bail, or the Secretary of State agrees to release them, but there's a delay in sourcing Section 4 or bail, Schedule 10 bail accommodation. And the reason for that delay is often because it may be a foreign national offender, and there needs to be accommodation needs to be found that will be suitable. Quite a few cases addressing this issue. So in Mercer, or Merca, even though there had been difficulties due to COVID-19, they didn't excuse the extent of delay in sourcing Schedule 10 accommodation. AC Algeria reiterates the principle that suitable accommodation must be sought with reasonable expedition. It's not enough to say we can't find it. The Secretary of State will have to present evidence in any such claim to show that they're making efforts to find appropriate accommodation. In Humnitsky, the policy towards high-risk foreign national offenders in finding that accommodation was found to be systemically unfair, and you may well then find that unlawful detention claims can arise out of, on behalf of detainees who are affected by that policy. And then in Barizi, is a recent case where interim relief was granted because of quite extensive delays in arranging Schedule 10 accommodation. So when you're looking back at the history of detention, obviously you're also going to be scrutinizing any period where it's said that detention is delayed because of accommodation delays. Next slide, please. Another top topic that comes up a lot is the use of force. When is that reasonable? When can that give rise to the cause of action, either for assault or battery, because the use of force was unlawful, and additionally for breaches of Article 3 or Article 8 ECHR. And I've put here some of the sources of law that will be important to go back to. So you've got Section 146 of the 99 Act, force must be reasonable, and the detention centre rules sort of reiterates that, and the Detention Services Operating Standards Manual. which says it's only necessary to keep in custody for these for specific purposes, so to keep in custody to prevent violence, to prevent destruction of property, or to prevent someone from seeking to prevent their own removal or others' removal. But those were criticised to quite an extent in the Brooke House inquiry, particularly the practice that seemed to be quite widespread of handcuffing detainees behind their back while seated, which gave rise to a risk of asphyxia. Not ensuring dignity while restraining naked detainees, and the use of force on those who are mentally ill. And there are quite a lot of recommendations in the Brooke House Inquiry report for how the Operating Services Manual needs to be amended to take account of that. I'm not sure that that's happened yet, and presumably the Home Office is still considering those. But that's obviously going to be arguments that you might use in your civil claims to say that the use of force, even if it was strictly within the Operating Service Standards Manual, was not reasonable or necessary. Haven't been able to find many cases covering this recently. I've put two there. So Shitty is a case where on the very specific facts of that case, the use of force while detaining was reasonable. So not particularly helpful. But AB and Secretary of State for Justice is interesting because it addresses the issue of solitary confinement and when that may give rise to a breach of Article 3. The answer being it's very fact specific and fact dependent. Last slide, please. So finally, just a sort of catch-all of some of the issues that are coming up in the case law and that might be relevant when considering whether you have a cause of action, particularly human rights claims looking at conditions and treatment while detainees are in detention. So I've mentioned NB, which is Mr. Justice Linden's case around the Napier barracks and conditions there. In that case, the conditions were inadequate, so they breached the statutory duty for asylum support accommodation to be adequate, but they didn't reach the threshold of Article 3 or Article 8. It was relevant in that case that there was sort of limited medical evidence as to the impact of those conditions on the claimants. So it's worth looking carefully at that and seeing if you can distinguish it if you want to argue that the conditions in which, and obviously a key distinction between your context and NB would be where the person is kept in detention. And I think that was a point that was in fact made by Mr. Justice Linden. On the issue of neglect, AB and Worcestershire is potentially helpful, very different context, but it covers claims by children who were suffered neglect due to errors made by social services. And the court confirms, and this issue was in dispute at some point during the litigation, but the court confirms that just pure neglect itself without adverse treatment is sufficient or can be sufficient to give rise to a breach of Article 3. There doesn't have to be a physical chastisement. And so that may well be relevant where you're looking at a situation where somebody has suffered quite significant neglect whilst in detention. Restitution claims, have a look at ASY and Home Office, looking at the claims around the procedural failures following the under the no recourse to public funds condition. Electronic monitoring, we've touched on a bit, there the court found there was a breach of Article 8 due to the Secretary of State's failure to consider whether electronic monitoring condition would be impractical and a failure to consider representations. So there may well be damages claims arising from the inappropriate imposition of electronic monitoring claims and monitoring requirements. But there are also damages claims arising from the inadequacy or defects in the electronic monitoring equipment itself. Some of those claims may lie directly against the electronic monitoring service or against the manufacturer or user of those equipment or against the Home Office. So there are interesting issues there around claims for negligence and false imprisonment where people are detained because of their faulty equipment. Access to legal advice, the court in SPM essentially held that the issues around LASPA and availability of legal aid did not give rise to unlawful, did not render detention unlawful, and essentially the court held that that was a collateral claim that should have been brought against the legal aid agency. It didn't go to the heart of the detention itself. And then in case you have any claims arising from access to medication, there's an interesting settlement on Duncan Lewis's website involving a series of claims involving detainees who are kept in confinement for 24 hours on a bus without water or medication, and another detainee who was kept where there was a failure to ensure consistent access to antipsychotic medication. And I can see from the website that the Home Office accepted in that case that there had been a breach of Article 3. That concludes my talk, and I think now we're going to be passing on to Maya to discuss quantum.
Thank you so much, Mike. Yes, quantum. Could I just have the first slide, please? So I've started with an overview table, which I've actually stolen from 3 of my very clever colleagues. And I did that because they had put together this table which helps you to see the difference between basic, aggravated, and exemplary damages using case law directly arising from immigration detention, as opposed to all the case law that arises historically from police and prison law cases. So sometimes it's difficult to unpack the 3 areas. Basic is straightforward in a sense because it is the actual loss of liberty and then the humiliation, loss of reputation, and the psychiatric issues that go with it. And with aggravated damages, it's sometimes difficult to work out whether you can argue for them because there is a crossover, particularly when we're dealing with feelings. But I suppose what this shows us, these quotes show us that the focus for aggravated damages is the manner in which the tort is committed, and also, as you'll know, the conduct after that tort is committed. So often behavior during litigation will sound in aggravated damages. It is repeatedly said in all the case law that aggravated damages are compensatory, but of course it's difficult to square that with the suggestion that you only get AGs when behavior is exceptional. So if a defendant's exceptional behavior is a precondition to the award of AGs, then it sort of casts some doubt on the purely compensatory nature of aggravated damages. And there's mention of that in Thompson and Shue, when it is said that although they're not intended as punishment, they will in fact contain a penal element, which may then impact on whether you can recover exemplary damages. So, and exemplary damages, as you know, can be quite rare, although less so in immigration detention than in other areas. In police cases, it's harder to get exemplaries. I think from my experience and practice, but as you know, the conduct in those cases has to be outrageous. So next slide, please. Camilla, next slide, please. Basic damages, and despite it being an updating seminar, Thompson and Shue remains the lead case in this area. You'll all be really familiar with it, but nothing has beaten it yet. And you'll also all be familiar with MK in Algeria, MK Algeria, and that looks at the way in which Thompson and Shue should be approached. As you all know, it's a fact-sensitive assessment in basic damages. It's not mechanistic. And the important point about Thompson and Shue and subsequent case law is recognizing that those damages are front-loaded in unlawful detention cases. That is to say, you get more for the initial period of detention, and then you have a sort of reducing scale. You'll all know that you have to have a tapering approach to calculating damages. And of course, if there isn't the initial shock, or the initial period of detention was in fact lawful followed by unlawful, that's also factored in to damages assessment. Thompson and Shue guidelines have set that the starting point 500, which I've uplifted, and the 24-hour figure of 3,000 is now worth around £8,000. You'll all know that you have to update using an inflation calculation, and there's a tool that's available which I use. I prefer the Kemp and Kemp PI inflation calculator, just because the one on Lexis just seems to crash all the time, and the advantage of the Kemp and Kemp PI, I'm not trying to sell a product, by the way, but the advantage of that inflation calculator is that it also factors in, it asks you whether you want to add in a 10% Simmons, a further 10% uplift. And those, as you all know, come about when you're looking at comparators. If you're looking at a judgment that was handed down before the 1st of April 2013, then you want to add the 10% uplift, and that inflation calculator is helpful because it does it for you automatically. Next slide, please. So I wanted to look at sort of favourite cases, which again you're all probably really familiar with, but for the longer periods of detention, AXD remains the best case, or the most useful case, because Mr. Justice Jay was quite generous, or rightly so, with the figures that he awarded in that case. And you can see that 20 months and 5 days was 80,000, which now I did the calculations, worth 116,932. So and aggravated damages of 25,000, now worth 36,500. It's also helpful to look at the alternative periods that he came up with, in case you have those periods in the cases that you're doing. I've operated the figures for you there, but you get a sense of where you land now in 2024. The important point is that those awards factored in, the basic awards factored in a fear of return to, in this case, Somalia, the regime, in particular in Wood Hill, which was a prisoners at post in immigration removal centre, and there the hours of bang up at that time were 21 hours. In fact, these days probably closer to 23-hour bang up. which increased the amount you got for basics, and then the personal difficulties that AXD faced with sexual orientation at both those institutions. But it's worth noting what he said, and the other cases that were used as comparators, that he had to stand back and look at the court's sense of the overall justice of a case. And he talks about having a free hand and not being assisted by the other case law that was put in front of him. And as you can see there, he says, I refrain from applying a mechanistic approach and or one tethered to the application of any daily rate. So you must not try to calculate it by way of by using a one case, dividing it by the length of the detention, and then try to come up with a daily rate. It won't get you where you need to be. Next slide, please. And the justification for aggravated damages in AXD are useful because they probably apply across the board. The drift in the decision making, and with the number of senior officials not doing what they were supposed to, the suboptimal treatment for the mental health condition, the lack of welfare plan when being released, and that he should have been provided with the unpublished information relating to returns on the facts of this case, Mogadishu. But those aggravating features, most of them will arise in other cases, so it's useful to go back to those. Next slide, please. So it's a shorter period of detention. I focused on two cases which I find quite useful, which are the more recent cases. And there you've got DEPCA, you'll all be familiar with it. And here you have 154 days of false imprisonment, which seems to be a common ballpark of 5 months, 4 months. In fact, it's exactly the same number of days than in the case as in the case of Santos, as I put here. And you'll know that this was a case about 2 Polish nationals who were rough sleepers, and you can see that the figure is worth now about £47,614, which is slightly lower than Santos, which is worth more because you have to look at particular facts, but not dissimilar to Musa, which was fewer days, but slightly more, 49,613. But you get a sense of what you can recover for the 4 to 5 month period when you look at these cases. I put, there were no exempts recovered in that case, but you can see that they were aggravated damages, and I've set out there the reasons for AGS in that case. Next slide, please. The other shorter period sort of case that is useful is Halonia, which is again another Polish rough sleeper case, and you see here it's another 5 month mark case, 153 days detention, 37,000, which included 6,000 for the initial shock, and because he went on a hunger strike, that is reflected. That was a further 5,000, but it wasn't sort of split up as basic and aggravated. It was said in that case you can look at them, look at it in the round, and the features that the court bore in mind in particular, that this was a first-hand that the hunger strikes reaction to the detention. Next slide, please. Next slide, please. I'm not going to go through this because I'm conscious of time, but I've set out the circumstances from as they were encapsulated in Halonia for the circumstances in which you'd be likely to get aggravated damages. Of course, you look at Thompson and Shue to see how you would assess those damages. So they're unlikely to be less than around 2.5 to 3K. I've just I've operated the figures, and they won't be double the basic and don't double count. Those are the messages from Thompson and Shue. But you can see here, again, there's that sort of reference to the manner in which detention was committed. A motive is also something that could attract AGs. And again, the conduct, so one has to look at the way in which litigation is conducted. And as you all know, if there's a failure to apologise, and what's described here is rubbing salt in the wound, not only have you detained this person unlawfully, then you're refusing to take responsibility for it. That will sound in aggravated damages. Next slide, please. Exemplaries, again, look at Thompson and Shue's how to assess them. So not usually less than 5 or more than 50. Of course, those have to be uprated. So you're talking about a minimum around 14,000 and a maximum of around 135,000. Are you going to get exemplary damages? Again, it's a matter of judgment, and the more of these cases you do, the better feel you'll get for whether it is so arbitrary and so outrageous as to sound an exemplary damages. But that it is quite different from aggravated damages. So they are rarer kinds of damages, as you'll know. But the bar doesn't have to be as high as malice or fraud or insolence or cruelty, as was said in Musa. Next slide, please. All right, so I wanted to look at the other kinds of damages that you may be able to recover. Although everybody always pleads a range of breaches of the Human Rights Act, including Article 5, you're not going to recover Article 5 damages if you're recovering for unlawful detention. Or certainly, I've never seen it. There are other Human Rights Act breaches that you may be able to recover from in addition to your tortious claim. For example, an Article 3 breach, and I think Mike was mentioning solitary confinement. For example, it may be that you've got a standalone Article 3 breach which isn't swept up in your aggravated damages. Perhaps segregation of an extreme kind, such as solitary confinement. Perhaps you've got an investigative duty type claim, perhaps in a trafficked victim claim. It's when you're looking at whether there may be a crossover. There is a recent case called AXO, which was decided in a completely different context, looking at the crossover between seeker damages and HRA damages. And it's a really it's a good judgment to look at. It's Lady Justice Whipple. She looks at the sort of nature of Human Rights Act damage, and particularly the moral nature of those. So it's a very interesting read, and it helps when you're trying to say this is not double counting. There is some analysis in the case that Mike spoke of, which is the destitution case of ASY, as to when you can recover damages in Article 3. Pain, suffering, loss of amenity in those cases where you've got psychiatric damages as part of your basic. Always look at the Judicial College guidelines now in its 17th edition. You will need an expert report. And as I've said there, try to address prognosis as well as treatment, and also try to get the expert to look at the guidelines and see where it falls in those brackets. See if you can get exacerbation in percentage terms so you can quantify. Specials, do you have any pecuniary losses? Do you have medical treatment, psychological treatment? And lastly, you may be able to cover the costs of a court of protection deputy. In fact, you should. There is case law to that effect. If you've had to use a specialist deputy because the claimant lacks financial capacity and the funds itself need management. Right, yes, that is my last slide, and that's the end of what I'm going to say to you about quantum.
Thanks so much, Maya, for telling us all about the money. Now for a bit of a practical update from me, which I'll be keeping because it's dry for even the most hard-nosed procedural whiz kids out there. I'm going to confine this to recent issues that have come up in the context of immigration detention, including in judicial reviews, which have been transferred to the county court. And I'll pick up a couple of interesting nuggets that might be helpful in practice in the time. First slide, please. So venue, the basics. In practice, ordinary private law, Part 7 civil actions in the immigration context, if the client is at liberty and no remedy beyond a declaration and damages is sought, these claims should be issued in the county court or the King's Bench division. It's not, that shouldn't be issued as a JR. The venue in this context is determined by the value. So a pure claim for money in which the county court has jurisdiction, which it does in false imprisonment claims, may only be commenced in the High Court if the value exceeds £100,000. If there's a PI aspect, then the damages need to be, the estimated value needs to be more than £50,000 to be in the High Court. Otherwise, the thrust of the CPR and the jurisdiction order 1991 is that claims should be in the county court. And even if the value does indicate that the claim could be in the High Court, if this is without prejudice to a possible transfer taking place to the county court, and you may need to justify why a High Court trial is suitable, given the importance of the action, the parties, the public interest, complexity of the facts, legal issues, remedies, procedures, or which venue is likely to result in a speedier trial. Next slide, please. In the context of immigration detention, where the client has been released, there are clear tactical advantages to bringing, issuing in the county court rather than bringing a judicial review. Obviously, there's no permission filter, better disclosure provisions, opportunities for oral evidence, and early settlement. However, there are, of course, immigration detention claims for declarations and damages which do need to be issued in the administrative court. Clearly, if the client is detained, or not, if the client is not detained, but you're seeking one or more public law remedies, possibly on a time-sensitive basis, these might include challenges where there's a parallel immigration challenge or trafficking challenge. However, the admin court will still want to transfer those in many cases. Other cases are those where there is a systemic challenge to the operation of the defendant's detention policies. An example I've given there is the case of LC, a case challenging the defendant's failure to put in place an Article 3 ECHR compliance system for detainees with HIV following the judgment of Mr. Justice Bourne in the case of CSM. The court was persuaded to retain, even though LC had been released, the court kept it in the administrative court to determine it because of the public law remedies being sought in terms of the challenge to the policy. Ultimately, this case reached a successful compromise, and the reason that I've highlighted it on the screen is because Mr. Justice Fordham gave an open judgment giving effect to the terms of the consent order and required the parties to file a statement of reasons as required by the Administrative Court Guide, paragraph 24.4.1. And what that did is that it revealed the public law, even though a compromise was reached and ultimately the private law claim was transferred to the county court, the open judgment revealed the policy challenge that had been in issue in that case. Next slide, please. I should say also a helpful, if you're bringing a policy challenge in a judicial review and challenging the legality of the detainee's detention, and for example you get bail in the course of proceedings, if at the point of interim relief you're able to persuade a judge to observe or include a recital that the claim includes a public law remedy and it ought to be kept, or there's a good reason for it to be kept in the administrative court, this may well help you down further down the line, although of course it's not binding on the next judge. Next slide, please. In short, the CPR was amended recently to include various provisions on transfer. And just to say here, in terms of settlement following transfer, there's been previously a practice was permitted for stays to allow the parties to negotiate a settlement. So once a notice of transfer had been issued, the parties would have time to settle the claim, normally for 3 months, and you may be able to secure further extensions of time to settle the claim before filing statement of case. That's changed somewhat because you may only get a, say, 2 to 3 month stay and then be required to file a statement of case with negotiations to continue alongside. And of course, in a case where a JR has been transferred, the county court will not tolerate the JR grounds standing as the statement of case, and you'll be required to file a statement of case which is compliant with the practice directions. And Ali is an interesting case about of Mrs. Justice Heather Williams, which is an appeal against a county court judgment. So there's Ali number 1 and Ali number 2, and Ali number 2 dealt with some consequential issues in terms of liability and quantum being retained either in the administrative court or being remitted to the county court, and only a stay of 2 months being granted as being reasonable, having regard to the whole history that preceded it. Next slide, please. I just briefly dealt with statements of case in the county court, and I was hoping to say a couple of words just to spice things up about the Wagatha Christie trial at the end. The Vardy and Rooney case there, which makes the point, of course, that statements of case shouldn't be too long, and obviously that's the case. We'll know that where Rebecca Vardy's agent's phone ended up in Davy in the bottom of the sea in Davy Jones' locker. Next slide, please. Just a couple more points before closing, to have some questions. Expert evidence. The rule in Practice Direction 16, paragraph 4.3, is that in PI claims which rely on evidence from a medical practitioner, the claimant must attach a report to the particulars of claim to statement of case. Now, there's a couple of cases there, Mark and Universal Coatings, and a case of CDE and Buckinghamshire, which suggest or which say that there may be a good reason not to annex a report, although this might be a case this would be a case wouldn't necessarily raise PI issues, but you were still relying on a medical report, and that clearly comes up in false imprisonment claims, where you want to rely on a medical report either for issues of causation and then on quantum. And the good reason to rely on that potentially later is because it may be helpful to have evidence later on that's more relevant to quantum than liability. And Louis is a really interesting case where there was a long trial in which the defendant's expert and the claimant's expert gave evidence, and there was a difference in the evidence about causation of the claimant's depressive disorder. The claimant's evidence being that this was caused by detention without any without any end in sight, and the defendant's evidence being that there were pre-existing factors. And the court preferred the claimant's evidence due to for its reasoning, and also because the defendant's expert lacked experience of working in or with those in prisons or custodial settings. Next slide, please. I think just to say, the next couple of slides, there's a couple of cases there about defendants' witness evidence, which you can read. It's mainly about the issues of witness availability. And then finally, the final slide, please, deals with disclosure and secret policies, which is a huge topic. I think in 2012, when Lumber was decided, everybody got deeply excited if there was a secret policy in the context of immigration detention, and now we seem to find them every day. So there's a whole host of cases there that we can look at, and issues of disclosure, which are interesting and perhaps for another day. We've 1 minute for closing, and I don't see any questions in the Q&A at this stage. So I'm wondering, Mike, you've had a question.
I think that's because we've answered them on the Q&A, so maybe that everybody can see the answers. But there was an interesting question that Brenda brought up about the Bibby Stockholm and whether that could constitute an unlawful, a false imprisonment, and whether those arguments have been run. And I believe from colleagues that they have been run, and those claims have tended to be settled by the Home Office. But the arguments that are also coming up, I think, particularly in Wethersfield, and in Benali cases as well, is around Article 8, so restrictions on freedom of movement and damages claims, as well as JR claims for those restrictions. So that's quite an interesting area to look at. And I think there's a case on the Wethersfield, a judicial review in July.
Thank you so much, Mike. I can't spot any other questions. Maya, did you want to add something there?
No, no, Catherine, I had answered a question about because I'd said about being able to recover the cost of a deputy, and a proper question was that the belief about recoverability would only be if in fact the Home Office had caused the lack of capacity, or the tort had caused the lack of capacity, as opposed to when somebody needs deputy because they had no capacity before the tortious conduct. But in fact, what I was trying to say is that really right? Because in tort, you have to take the victim as you find them. And so you should argue that that those special damages should be covered, regardless of how you became incapacitous.
Thank you so much. Thank you so much, Maya. Thank you, Mike. Thank you, everybody, for joining. Unless there's anything else, I think we can close the webinar and wish everybody a lovely afternoon and the best of luck.
Bye, everyone.
Thank you.
Thank you so much, Catherine, for chairing. Thank you.